This exchange
before they're removed?
before
it certainly wasn't in Kentucky.
in this case, this action was filed before they were removed and included habeas claims and obtained relief.
Are you agreeing that what they have a right to do is notice and an opportunity? Not going to be a long opportunity, I would assume not, but a reasonable opportunity, a fair opportunity to seek the type of review that's allowed under the AEA of whether you qualify under a proclamation terms. Do they have a right to do that before they're put on an airplane?
Your Honor, I think the answer that this court provided in IM is if you bring such a challenge in habeas before you're out of custody, that can be brought.
No, that's not my question. My question is, because the government's in complete control of when these people get put on airplanes or not. So my question is, I mean, if they're lucky enough to bring it, that's one thing. I'm not asking that question. I'm asking, does the government agree that they're entitled to notice that they are being removed based on their status as a member of Tren de Aragua under the AEA proclamation, the president's proclamation under the AEA, and an opportunity to challenge that before they are removed from the United States?
Your Honor, we don't agree to the notice point. We agree that if you bring habeas, that you can raise such challenges and that they can be heard.
I don't know how you can bring habeas if you don't have notice.
Well, Your Honor, 5 individuals did here.
So no, they anticipated it. They filed before there was even a proclamation. And so if we were to rule for you, it sounds to me like if we were to rule for you and vacate the TRO, the government considers itself fully within its rights to pack every member of this class, including the 5 named plaintiffs, onto an airplane before there's a chance, reasonable time to file habeas petitions. Is that correct?
Your Honor, I think as we've discussed right now, there's nothing preventing these 5 from filing
That's
habeas
not my
action.
question. My question again is, if we were to grant the relief you request, would the government consider it necessary to allow time, notice, and time to file a habeas petition before removing people under the proclamation? Or would it, anyway, that's A, or B, is the government's position that it could immediately resume mass removals of these 5 named plaintiffs and the class members immediately? A or B? If you've got a C, you can tell me a C.
Your Honor, I think it's B, that we take the position the AEA does not require such notice, but that certainly in this period, these 5 plaintiffs could bring habeas claims right now and are electing not to do so. They could bring it in the correct court, and they've identified no obstacles to doing so.
There's a whole class before us. You haven't moved to vacate the class certification. I don't know why you keep talking about these 5 people. We've probably got hundreds of people before us, and I'm asking about those hundreds, including those 5. And as to them, I understand your answer is B. The second we vacate, if we were to do that, people are lined up and put on planes without notice or time to file for habeas. Even though the government agrees that decision, they have a right to have the decision made about whether they even qualify under the proclamation.
Your Honor, if the TRO is dissolved, the government believes there would not be a limitation and that the statute does not require such notice.
Does the government have any obligation with a class certified to notify counsel as to where these individuals are that are being removed, and so they even know which jurisdiction to bring a habeas suit in?
Your Honor, I don't believe that plaintiffs have sought such relief. I don't think the district court has ordered it. And so
notice. It's not notice. And it seems it's the government here that says you got to file habeas actions. The whole solution here is habeas actions. Let's all have habeas actions. So it would seem a bit rich for the government to say, but we're not going to tell you where they are or where you need to file or give you time to file at all.
Well, Your Honor, they certainly know where their own clients are, and they're refusing to file in the proper court.
They don't even know how many are in this class.
As
you can talk about 5. That's they represent way more than 5. I don't understand why we're just talking about 5. That's a point of class action.
Your Honor, they could certainly file in habeas. They seem to care about their
They can't
form
file
more
in
than
habeas
the.
unless they go to the right jurisdiction,
I absolutely agree with that premise, Your Honor,
If
which
they
is why
don't
they
know
need
where
to
they
file
are,
in Texas.
and the government won't tell them.
They know where at least some of them are, and they're
That's no.
they're
to everybody
affirmatively
else.
refusing to bring habeas in those jurisdictions.
And there's, not refusing, they've declined, they've made a choice not to, that's supported by an awful lot of precedent. But that's not the point. The point is well, you must know how many more people are in this class.
Your Honor, there is a declaration that provides the estimate. I believe it's the CERNA declaration, filed on Tuesday or so. I don't recall the specific numbers, but it is in the record.
Are we 100? I'm sorry, I looked at
My
it.
recollection is it's in around 300 or so.
300. Is every one of them in the same jurisdiction in Texas?
Your Honor, I don't know that question.
They don't either. Hard to file. The other thing I just wanted to clarify is, it seems like you're sort of both crossing over here. The written TRO doesn't say anything about bringing airplanes back. It just says that you shall not remove people that are within the class. But it was in his oral direction, which you say was not, unless I've misunderstood the position. My understanding from government's position in district court is that was not a binding order until it was reduced to writing. And so when you're asking us to vacate the TRO, are you asking us to vacate the written TRO, which is one that you say is legally operative?
That is what we are asking this court to stay or dissolve. But certainly, I think plaintiffs are taking the position that that incorporates more than what is it within the four
But you're
corners
not.
of its writing.
Right, but you're.
We take a contrary
position.
position, but jurisdiction in no way depends on the merits, as the Supreme Court has repeatedly explained.
Okay.
All right, you want to wind it up?
Yeah, very quickly, Your Honors. On the habeas point, you've heard that it could be brought in habeas. Labue means that it needs to be so. We've also heard from opposing counsel right now that they intend to bring evidence of individual cases. I think that's important for 2 reasons. It is in severe tension with commonality requirement of a class. They're now getting into very fact-bound characteristics that are inconsistent with class adjudication. And I think it just again underscores how much this is sounding in habeas. My particular circumstances warrant you not exercising custody over me is a classic habeas claim, and it should be brought as such.
All right, thank you.
Thank you, Your Honors.
Honorable Court now adjourned until Tuesday, April 1st at 1:30 a.m.